Fredrick versus Costco.
Settle up.
Mr. McHugh, you wanted 5 minutes rebuttal. Is that correct?
Yes, ma'am.
Okay, you got it.
May it please the court. My name's Andy McHugh. I am Fred Short's lawyer. Fred was the plaintiff in the court below, and he appeals the district court's order granting Costco's motion for judgment on the pleadings in his slip and fall case against Costco. I know you've read the briefs and understand the facts. Fortunately, in my case, the facts are super simple, and they're contained in one paragraph on page 2 of the district court's memorandum decision. So at risk of doing something I'm not supposed to out of the box, I'm going to tell you what they were. Plaintiff went into the Costco store over here in Johnson County back in April, intended to buy a box of frozen chicken mini tacos. He was pushing his cart through the store, realized he needed to get those chicken tacos. So he goes back to the freezer section where they were held for sale with a price tag on them, picks them up, puts them under his arm, heads back to his cart. And as he does so, the box collapses. Fred slipped on one of the tacos. It hit the ground and hurt himself. So we filed a petition, an amended petition alleging that Costco had breached the implied warranty of merchantability. That is in section 2-314 of the Kansas statutes. I think it's 84-2-314. And Costco filed a motion for judgment on the pleadings. And the court described, really crystallized what was going on, also at page 2 of the memorandum opinion. The court says the watershed issue here is whether an implied warranty of merchantability attaches or becomes actionable only after the point of sale / transfer of title to the goods, which is what Costco said, or at the point where the customer, hopeful buyer, takes temporary or presumptive possession of the goods upon their removal from the shelf in the merchant's store prior to payment. That's how he characterized the issue.
I have an underlying question.
Sure.
Why isn't the manufacturer of the box that collapsed a party in this action?
Well, there's a couple of reasons for that. One is it'd be a products liability case, right? And I'd need the product, which I don't have, is gone. So it'd be impossible to prove that case. Not to mention, it'd be a very expensive undertaking to try to demonstrate that a box was defective under those circumstances. So as a practical matter, Fred is left with no remedy if he can't go forward with his implied warranty claim.
What did Costco do wrong if your client put the box of tacos under his arm, and I assume he put some pressure on the box to hold it?
Not necessarily. I mean, enough to carry it. I say under his arm. I don't know if he was carrying it like a football or what he was doing. He probably testified about that in his deposition, but I didn't represent him at the time, and I don't know. But Costco doesn't have to do anything wrong for a warranty claim.
I'm not saying they do, but I'm just trying to figure out the semantics of this case.
Sure. And really, I mean, that's what those warranty claims are for. It's like all of the cases that we cited, albeit from other jurisdictions, although Kansas has a line of exploding bottle cases. I mean, you pick the carton up, if the bottom drops out and the bottle explodes, that's a warranty claim. If you go to set it on the conveyor belt and the bottle explodes, that's a warranty claim. And specifically, the code talks about, or the jury instruction talks about, inadequate packaging or inadequate labeling. Well, this is inadequate packaging. And so effectively, being that we can't make, as a practical matter, a product's liability claim, the product's gone and it costs prohibitive, Fred's left with no remedy.
So let me follow up on that. I mean, and I appreciate the practicalities of this, and you're trying to get him a remedy, and you weren't his original attorney, so I appreciate you stepping in. But isn't this really a products liability case? KSA 60-3302C says, product liability claim includes any claim or action brought for harm caused by the packaging of the relevant product. It includes, but is not limited to, any action based on breach of express or implied warranty. An implied warranty of merchantability claim relating to packaging appears to be inherently a product liability claim.
I'm not going to disagree with you about that, although that,
But you just said that you can't prove a product liability claim.
well, I can only prove it in the context of an implied warranty, right? I'm not familiar with that statute. This has never been raised as an issue by anybody before. So I don't know. And if that's a statute that says that it supersedes everything else.
Well, it just defines what a product liability claim is
Yeah.
in Kansas. And then it goes on, and I'm sure this is why Judge Schroeder asked you, because then if you look at KSA 60-3306, then it talks about when you should file a lawsuit against the manufacturer versus the seller. And of course, you can reach the seller if certain elements are met. But it does seem like this is a product liability claim.
Well, I don't think that the fact that it's a product's liability claim means that you can't pursue a breach of warranty claim also. But maybe that's what that statute says. As I say, I'm not familiar with that one at all. And I can't prove a product's liability case because the defendant took the product and did something with it and is gone. So I don't quite know what I'm supposed to do in a circumstance like that.
So this is a unique case in that it's not decided on summary judgment. It's not even a 12B6 motion. It's a judgment on the pleading. Did the judge look at anything outside the pleadings, or did he just look at the petition?
You just look at the pleadings, and really judgment on the pleadings is sort of a glorified motion to dismiss. I mean, that's all it is.
Seems like it's really the same as a 12B6.
Exactly. It's exactly what it is. And, he's wrong on the law. I mean, the reason that I read the sections that I read is if you read the code, it specifically says the breach of implied warranty arises from the making of the contract, offer, hold out the product for sale, acceptance, pick it up, intending to buy it, got mutual promises, I'm going to pay for it, you're going to sell it to me, it's a contract. That's an implied
Well, do
warranty
you have
claim.
mutual promises, and it probably wouldn't hurt your case, but it seems to me that's a fact question whether it was mutual promises.
Well,
Because that jury would, if let's say this went to a jury, would have to decide, did he really intend to buy it or not? I mean, I've been in the store before where I've picked up two of the same basic items, different manufacturers, and then I don't decide until I'm getting ready to leave, okay, I want this one, not that one. But I think what you're saying, if I'm hearing it right, is that there's at least enough here for a fact question.
Well, I'm sort of saying that, Judge, but first of all, with respect to a motion for judgment on the pleadings, everything gets construed in my favor.
Right.
All right. Secondly, the fact that somebody could cancel the contract, which is provided for under Section 106, doesn't mean there wasn't a contract to start with. So if you pick it up intending to buy it, which is what Fred did, that makes the contract. And I can tell you, because I do remember this much from looking at his deposition, he was working for Instacart at the time. So he went in there to buy the frozen mini chicken tacos because some customer of Instacart wanted it. So this was not going to be a question of him changing his mind. In addition to which, under the standard of review, the court has to accept as true that he intended to purchase them, which is what I pleaded. Okay.
Now, Kansas does not, you've cited the Oklahoma case, you've cited, I think, a Maryland case. Kansas has not really this is a matter of first impression for Kansas because, you just take basic contract law, you have to have, and I think you've got all this, and I don't think they dispute this. You have to have an offer, an acceptance, but you also have to have consideration. And it seems like what you're arguing is for either a change or an extension in Kansas law to say that the consideration can be just my subjective intent that I am going to pay for this at the checkout, not just picking it up off of a shelf.
That's correct. And that's what I pleaded, that he picked it up to purchase it. That's right.
But that would require a change in Kansas law
No, sir. I
or
don't
an
think so.
expansion.
I don't think so. I mean,
Was there any Kansas case that says that just picking up a product off of a shelf is sufficient?
I cited any cases that say that. All of the cases I cited, including the ones from sister jurisdictions, say that the acceptance is picking it up off the shelf, intending to purchase
That's acceptance, but what's the consideration?
Well, it's a promise to pay for it.
Paid until checkout.
Well, but that implicit in that is I'm going to pay for it when I get to the checkout line.
Right. And see, that seems to be the extension of Kansas law is it would be that the fact that I'm intending to pay for it in the future is sufficient to be consideration.
That's right. It is. It's an executory contract. It's classic. It's a bilateral executory contract where the parties exchange mutual promises. Costco promises to sell it at a given price. The plaintiff promises to buy it at that price when it gets to the checkout stand.
Yeah, it just seems like the consideration, but this is a motion for judgment on the pleading. So we do have to view the facts. What you put down in the paper is what we have to look at. And
you also have to look, I suppose, into the judgment on the pleadings at the defendant's answer or whatever the response is, and they never said there was no consideration. So, it's a contract.
Well, I think they did because the whole Judge Vino's ruling was basically that the sale isn't completed until payment is exchanged. You're saying no, it's an executory that the consideration actually happened before that when he took possession of something they were offering, he accepted it, and he's intending to pay.
And it's not me saying that, Judge. I mean, it's the code. Section 401 specifically says title passing is not determinative. Section 401 explicit about that. That we're and to your point, it does affect to a degree a change in Kansas law. UCC does anyway, because they went away from this idea that you had to have a transfer of title and said instead, we're going to evaluate these things in the words of Section 401 based on the step-by-step performance or non-performance of the contract. And we're not going to do this title business. And all of these cases that I've cited from sister jurisdictions are completely on point, construing identical provisions of the uniform commercial code. It's the same stuff. And they've gone, and every one of the cases that I cited specifically rejected this point of sale, transfer of title notion. So,
well, there's only 2 or 3 jurisdictions that have even decided this issue, and they decided like 50 years ago. We were young men when that happened.
You're right about that. And
why don't we have any cases since then?
Well, I don't think
in any state other than the ones you cited, basically.
That's exactly right. And so 4 times it's been looked at, 4 times courts of appeal or Supreme Court have interpreted these identical provisions this way. And so in all likelihood, people stopped making this argument or stopped convincing trial judges, or trial judges stopped accepting it because they knew they were going to get reversed. That's how that works. You know how that
Or
works.
they could have just settled them out thinking this is not worth it.
Well,
bad facts make bad law.
Well, maybe, but I really do. I'm confident there's a line of cases in Kansas about exploding bottles. And, those may be pre-sale or they may be post-sale, but this is the exact equivalent of that.
But here, this is not an exploding box. It doesn't sound like.
Well, it didn't explode.
Sounds like something in a lot of those cases, of course, somebody lost an eye and things like that, and they definitely were product liability cases. But
Well, I mean, and Fred's got, $100,000 worth of damages, depending on how you look at it. You got to go paid medical bills, not paid medical bills, et cetera, et cetera. But it's not like he wasn't hurt.
right,
I mean, if you accept Costco's position about that, well, if something happens to somebody in our store before they've paid for an item, we're not responsible for it unless you can make a products liability case out of it. And that's just not always a practical way to go about it.
You said earlier he was working for Instacart.
He was.
So was he covered by workers' comp?
I know. Not to my knowledge, you make a work comp claim. I don't know how that works. Yeah. And once again, that's not a defense that these guys have raised.
No, I'm just wondering if he was,
Yeah.
you've talked about his damages. I just wanted to know
you're just trying to help him out.
if he was covered, got reimbursement for medical expenses through work comp.
He did not. I know, I do know that much, having looked at his medical expenses. Yeah.
Okay, we're way over your time now.
I figured we were.
Asking questions, so you'll still have your rebuttal time.
All right.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors.
Hi.
Pursuant to Rule 1-10, I want to introduce Justin Schott.
Right. Okay. I'm sorry. So it was your motion, not,
I filed the motion as the Kansas.
but it
On
was
his
to
behalf.
admit him.
Yeah, right.
Okay, so you are Wolf and you are
Good afternoon, and may it please the court.
Yeah, your name
I'm
is-
Justin Schock,
Shock.
Shock, Shock.
Shock. Okay,
Apologies for the confusion.
got it. Okay, no problem. We're happy you're here. Glad you could step in at the last minute. I hope everything's all right with Mr. Batty's.
I appreciate that. Thank you so much for approving our Pro Hoc on such late notice. We certainly appreciate it. All right, well, we'll dive into it. Good afternoon, and may it please the court. My name is Justin Schock, and along with my co-counsel Jefferson Wolf, we represent Costco Wholesale Corporation. Your honors, as my friend on the other side has pointed out today, this is a case of very basic facts with some detailed nuances whenever we're looking at applicable Kansas statutes here. Now, it is our contention that the district court got this matter correct whenever they held that no contract for sale had been effectively made underneath Kansas statute 84-2-314 at the time of this incident. Your honors, under the Kansas statute 84-2-314, an implied warranty of merchantability arises only when payment or title to the goods passes to the purchaser. Now, based on the facts within the record today, you'll see that no such payment for these goods was made at the time of this incident.
Where does it say that in this? I've got it right in front of me. Point to me where in 2-314 it says it's only when payment is made.
Well, now, Judge, whenever I'm referencing this, I'm looking directly to Judge Vano's memorandum decision.
But in our review, de novo.
Your review is de novo of that.
So why don't
correct?
we look at the law and not worry too much about his decision?
Yes.
So look at the pleadings and look at the law, because those are the two things we're going to have to hang our hat on.
Of course, Your Honor. And that points me to my next point of contention here. Whenever we're looking at the statute underneath section 1, one point of contention that the other side has raised today is the notion that it specifically states the serving for value of food or drinks to be consumed either on the premises or somewhere else is a sale.
The question.
Yeah.
His question
Well,
was on the
I
statute.
said, so I think you're telling me that it doesn't say that on its face.
Not on its face, Judge.
It's your argument. And the comment, it has the Kansas comment, it has the language about it applies to all sales by merchants. This warranty arises from the fact of sale and exists apart. So you certainly have an argument that may ultimately prevail. Because my issue is when the Kansas comment says arises from the fact of the sale, doesn't that at least he's at least pled, rightly or wrongly, that he had the full intent to purchase the tacos.
Well,
And
I
to
think that-
pay. So at that point, you'd have an offer. I take it you don't deny there's an offer and acceptance.
Your Honor, we do not deny that there's an offer and acceptance, but as you pointed out earlier during opposing counsel's arguments, there is certainly an issue here with consideration.
But isn't there some fact questions on that? I mean, it seems to me this is a bad way, even for your side, to decide Kansas law on some, because Kansas, this, with all due respect to co-counsel, this would require an extension of Kansas law at the least, maybe not a change, but an extension. Why was this brought up as and you maybe weren't involved, but why was this raised as a judgment on the pleadings, which is just a very rare thing in Kansas, not even 12B6 for some reason?
Right. Well, I think that is a question that I, as well as Mr. McHugh, have today. I was not on the case at that time, Your Honor, whenever that pleading was filed with the court. So that is a question for Mr. Brock, who is no longer with our firm at this time. I will say, though, Your Honor, while we're on the topic of consideration or lack thereof, based off of notions that have come about today, as His Honor pointed out, Mr. Short was an Instacart delivery driver at the time of this incident. Now, there are various nuanced issues with that I will not dive into, as we haven't previously discussed that. But if we're concerning matters of consideration, if it occurred at the time he picked up the tacos off the shelf, or at the time he would have placed it on the conveyor belt, there's also the issue with Instacart. If he is merely a delivery driver and is not personally paying for these items, would there even be consideration with that? So I think
These all sound like great fact questions that are not suitable for I don't doubt that ultimately you could prevail. I can see all kinds of defenses
Yes.
here. But we're way, way early in that.
Sure.
And again, if I was your client, especially a large company, this could really impact your client and others.
Absolutely.
If this court or if the Kansas Supreme Court adopts the Oklahoma case,
Right.
adopts the Maryland case. So it seems like, and I'm not trying to get you to concede, but I would say this, and forgive me for doing this, this is the old district court judge in me. Seems might be wise to try to get this thing worked out for both of you. There's going to be some bad law being made by somebody, and it's not going to end with the three of us. This is exactly the type of case that's going to go on up to the third floor of the Judicial Center in Topeka. So, but with that, go on with your argument. I'm not trying to get you to concede, but I think you recognize that there's some real, as Mr. McHugh said, on both sides, there's some real practical issues here. There's a whole question about products liability, and Judge Schroeder's question, who made these tacos? Do you know? I take it this is not a Costco taco.
I believe that assumption is correct, Judge.
Right, because they do sell food.
And it's rather good, dare I say.
Right. Well, I've had there, and I don't doubt that at all. And there's a certain exception under the statute
Yes.
for that, but we're not talking about that. We're talking about something in the frozen food section.
Absolutely.
So I'd like to jump on that if I could. The issue to me is, was this appropriate for judgment this early on? There are a lot of factual determinations that it appears need to be made. And this is a pretty significant decision in the law that seems like it would require a lot more ferreting out than happens at this stage, as a basically judgment on the failed to state a claim, judgment on the pleadings, whatever you want to call it. So what's your best argument for the fact that this was appropriately dismissed this early? That there was nothing else that could have been presented to change the result?
Absolutely. Well, Your Honors, as we've noted, even though this seems like a very clear issue on its face, there are some nuanced details to that. And that leads me back to the statute at issue here, which is 84-2-314. Whenever we are looking at the explicit language of that, and I will recite it before the court underneath section 1, it states, unless excluded or modified, a warranty that the goods shall be merchantable is implied in a contract for their sale if the seller is a merchant with respect to the goods of that kind. Now, as Judge Vano noted in his memorandum decision in this particular matter, he further alleges that the statute states clearly that the warranty of merchantability regarding the sales of goods, as stated, is implied in contract for their sale. Now, of course, in this case, whenever we're looking at the facts of the record here, there was no present sale as the subject goods giving rise to this suit were merely picked by the appellant. They were not placed on a conveyor belt to where that sale could have been finalized. Now, this brings me to my next point here. As
sale could, I mean, take it out of this context. There can be sales under the UCC where the final payment hasn't been made yet. I mean, that's done all the time. The party agrees, I agree to buy something from you. We have mutual promises. You're a merchant, or whoever's a merchant, maybe we both are. But it seems to me that what we don't know here is, it seems like everybody kind of, just as they avoid consideration, they avoid that in KSA 84-2-204, section 1, a contract for the sale of goods, which was the term we just used out of 2-3-14, is formed, quote, in any manner sufficient to show agreement, including conduct by both parties, which recognizes the existence of such a contract. Now, maybe you went on that. Seems to me you probably could, but this seems very premature to me. That seems like a fact question to me.
perhaps, Your Honor, that would be a fact question. I think if we go ahead and look into the comments underneath this applicable statute as compared to that of the Oklahoma statute that was previously discussed, that's where we'll start to see the discrepancies between the two, as well as what the Kansas legislature.
Part of that is because I got this 50-some-year-old case out there that they've added to their comments, but our comments say, number one, Kansas comment number one, this section applies to all sales by merchants. This warranty arises from the fact of the sale, which sounds like there could be a fact issue on whether there is a sale or is not a sale. So I'm just saying, for your own good, I mean, this would be fun to write up, but for your own good, you might want to think about this, because it seems like this is way early. Maybe summer judgment stage would be appropriate when the facts have been developed. But on the pleadings, I mean, I just don't see how there can't be a fact issue.
Your Honor, we can appreciate that there can be a fact issue with this, which is really why we have delved our argument more into the comments of the Oklahoma statute versus that of the Kansas statute here. Now,
we haven't adopted the Oklahoma.
Exactly.
Which is why their comments are different. I looked at those, but they're really immaterial to us. Other than if we were to say that Oklahoma case should be Kansas law, we find it to be persuasive, and it's now Kansas. And so every Costco in Kansas, every Sam's Club in Kansas, every grocery store in Kansas now has that as the law.
All determined from a judgment on the pleadings.
All determined from, one little piece of paper. That is dangerous. But right now, Oklahoma's comments really, I agree with you, they're different. But there's a reason why they're different, because they have a 5-4 Oklahoma Supreme Court decision. Probably all those folks are dead now. It was 52 years ago, if I remember right, who expanded the law, and maybe that should be the law in Kansas, but it doesn't seem like you decide that on the pleadings.
Perhaps, Judge. The 2 points I would make on that, and the first point being,
I should let you talk some, shouldn't I?
I appreciate the question. First point being is that the language of the statutes themselves, as pointed out within the appellant's brief, is substantially the same. However, whenever we look to the comments, comment 1 for both statutes, we'll notice that that is where we start to see the great discrepancies between the two. Now, based off of the interpretation of comment 1 in Kansas, it appears that the point of sale would not apply until there is a contract for sale made. Now, it remains our contention, and it remains, Judge.
Which is a fact question when that contract was made. It may be at the checkout stand. That's a good argument. It may have been before the checkout stand. But that seems like that is the fact question.
That is true, Your Honor. And that brings me to my second point of this. Whenever we're looking at these comments within Oklahoma case law that has cited the Oklahoma statute, it clearly shows that there need not be a purchase for sale at the checkout line or whatever you would like to refer to it as. Whereas in Kansas, there's nothing explicitly stated within any of our case law, nor the applicable statute making any such delegations to the matter. Further,
It could just be that it hasn't come up. I mean, I don't know that you draw any conclusions from that. I mean, to Judge Bruns, it may make perfect sense that you wait to the cash register. To me, it makes perfect sense that once I pick that up and put it in my cart or headed for the cash register, that's enough. I mean, if it explodes on me in the middle of the store, I shouldn't be without remedy.
And I would avoid it by going to stores, but that's a different issue.
Well, to be brief, Your Honors, wrapping up my argument here, once again, if we look back to this and to Judge Vano's memorandum decision here, we're really hinging on the words within the statute, the implied in a contract for their sale. Now here, once again, and I know, Judge, we've talked about this being a fact issue potentially, but there appears to be, based off of the clear textual interpretation of the applicable statute, that no present sale occurred. Therefore, the implied warranty of merchantability could not apply in this set of circumstances, which in essence would make Judge Vano's ruling appropriate under the plain text of the law.
Now, you would agree with me that 2.314 does not use the term present sale. That is a term of the UCC, but that's defined in 2-1061. And that's not in this. So it seems to me that under the implied warranty of merchantability, it's a little broader than that, because it's not necessarily thinking of the situation of Costco's. It's thinking of the situation where a business is buying, what did they used to use in law school? Bobbins, I think was what they used, and they bought bobbins and they had a contract to sell them or whatever. That when the contract is different. But I understand what you're saying about a present sale, but that's not in the plain language of statute.
And that would bring me to my next point here, Your Honor. Whenever we look at the holding of the Hodges Court, we'll see directly within that holding that we are focusing heavily on the word purchased here. And the Hodges Court further held that a plaintiff must show that the purchased goods were defective to demonstrate a breach of the implied warranty of merchantability. So even if we're having disagreements with opposing counsel on the plain textual language of the applicable statute here, I certainly think that the Hodges Court holding on this further supports our argument that there was not a applicable contract for sale that would allow the warranty of merchantability to apply based off of the circumstance.
That could be ultimately true. I would just say it's probably a fact question.
Okay, your time is way out. Okay.
May I be granted 30 seconds to briefly?
Yes, you may.
Sure.
Based off of the foregoing reasons, Your Honors, we would ask the court to respectfully uphold and affirm the decision of the district court based off the fact that there was no applicable contract for sale that would allow the implied warranty of merchantability or any applicable breach to have been effective at the time of this incident. Thank you.
Thank you very much. And thank you for subbing at the last minute. Okay, rebuttal?
Yes, ma'am. And I will say, as I'm walking to the podium, that one of the reasons these cases are 50 years old, and really they haven't gone, there's not been a lot of since then, is because the Uniform Commercial Code got enacted around about the middle 60s, the early 70s. So that's what accounts for the age of these cases. And so what that tells you is that some of the very first cases about this had to do with this issue. All of the courts that have considered it have specifically rejected the arguments or the reasons, the rationale that's put forth in the court's memorandum decision. And they have endorsed the position that we take, which is based on the letter of the law as enacted in the code, not the comments. And so I want to talk just briefly.
I will point out that there are cases from other jurisdictions that distinguish those cases. So
yeah,
it's not like all this, everybody has done that.
I have not seen those, Judge.
Well, I'll tell you a couple just for the fun of it. Leonard versus Tractor Supply Company, 2015 case in the United States District Court for Western District of Pennsylvania. And then I don't know know. I had to find the other one, but there are a couple out there that they distinguish it, but
I believe you.
I mean, you're right that there are cases that definitely say what you.
And so if you look at the code in Kansas, so we don't have to go to other jurisdiction, section 2-106, it says a contract for sale, which is what section 314 applies to. Contracts for sale includes both a present sale of goods, that's what Judge Vano was talking about, and a contract to sell goods at a future time.
Right,
That's
and
what
that's a
I'm
fact
talking
question.
about. Well, but it's what's pleaded. And what's
Right,
pleaded
which,
is to sell
if it's a
goods
fact
at a
question-
future time.
If it's a fact question, it means that you can't have judgment on the pleadings.
I don't disagree with that.
Right. So you don't want to fight with me
Unless-
too much on that point
Well,
because you might win.
I don't really, I'm not intending to fight with you. I want to be sure that if we go back and do this, what we ought to do, that we got a clear roadmap about what we need to do to prove our case.
Well, and we can't necessarily lay it all out, but I would cite you to the Products Liability Act too. Because
Right.
if you go back, you're probably going to have to deal with that. But there's nothing that stops you guys from settling this case.
I understand that.
And you might do it before we issue an opinion, which we'll try to do within the next 30 days or so.
You've likely never met a plaintiff's lawyer that says, I don't want to settle my case. And you sure aren't talking to one.
And you
now.
never met a former district court judge who didn't like his settlement.
Right. 2-206, which you mentioned, offer an acceptance in the formation of a contract. The offer is setting the stuff on the shelf for a price. Acceptance can be made in any manner unless it's limited by the defendant. They didn't do that. And just like we said, and all these cases say, except for those I haven't read that you mentioned, Judge, you can accept it in whatever manner you want, and picking it up with the intent to pay for it is acceptance. Section 2-401 is possibly the most important part of this. It says each provision of this article with regard to the rights, obligations, and remedies of the seller, the buyer, purchases, or others applies irrespective of title to the goods, except where the provision refers to such title, which section 314 does not. So what this tells you is title is irrelevant. That is exactly what comment 1, the 1996 comment 1 says. This section states the basic policy of Article 2 about sales in general. Title to goods is irrelevant to issues among the buyer, seller, and third parties. Yet Judge Vano's order is, oh no, it's what's determinative. That's simply incorrect. And finally, the proviso about this business of serving food and how, it called out this special issue for food service. And the court says, but they didn't make an exception like that for anything else. Actually, the whole reason for that proviso is to pretermit the difficult question of, is it a sale of a good or is it a service? I mentioned that in my brief. I didn't cite, for some reason, the 2 authorities that I found that specifically call that out. One's Quinn's Uniform Commercial Code, section 2-314A45, for goodness sakes. And then another one is called the Law of Product Warranties, section 216. And both of those talk about what was a difficult question before. What sort of legal theory can the plaintiff pursue in these instances where it's really about restaurants? Are they serving goods? Or strike that, are they selling goods? Food's not a good, sure wasn't before the code came along. Or are they providing a service? So that's what that's all about. So we'd ask for you to reverse it. I know you can't do it completely, but a roadmap to what we need to do to get there. And hopefully the defendant has heard what you've had to say about getting this case settled and paying us the money we need to go away. So thanks a lot.
We're not going to get involved in that, but
You're involved, Judge.
Public policy certainly does support settlement.
Yeah.
We can say that.
All right, y'all. Thank you for listening to us.
Thank you both.
for the overtime.
Thank you both very much. Very interesting argument. And we will take the matter under advisement and get a decision out as quickly as possible. Thank you.
Thank you all.
Conclude today's docket.
Thank you for your help.